All right, good afternoon, everyone. Welcome to the joint Hawaiian and water land hearing. We're hearing SB 2067 related to burial sites. This bill establishes an interdivision program between State Historic Preservation Division, County Burial Councils, Office of Conservation and Coastal Lands, and the Office of Hawaiian Affairs that addresses the location, movement, and restoration of Hawaiian burial sites, or EV, exposed or likely to be exposed to coastal erosion. And now, before I begin, let me start with some housekeeping announcements, and then I'll go to introductions of who's here. So this meeting is being live streamed on YouTube and also on my Facebook page. In the unlikely event that we have to abruptly end this hearing due to technical difficulties, the committee will reconvene to discuss any outstanding business. This will be on Tuesday, February 1st, 1 p.m. in room 16, and a public notice will be posted on the legislature's website. For testifiers participating remotely, your audio will be muted and video disabled until shortly before it's your turn to testify. I'll be reading a list of individuals who submitted written testimony for each measure. We apologize if the closed captioning doesn't accurately transcribe the names. If you're interested in reviewing the written testimony, please go to the legislature's website. There you'll find a link to the status page for the measure. Now, for my committee, I am Chair Maile Shimabukuro for the Senate Hawaiian Affairs Committee. My Vice Chair is Senator Jarrett Keokolole. And also I see present members. We have Senator Ocasio, Senator Ihara, and Senator Favela. And now I'll turn it over to Chair Inoue to introduce the Waterland Committee.
Thank you, Senator. I'm Lorraine Inoue, Chair of the Committee on Water and Land. And we say aloha to all of you as well. My committee, my vice chair for the Committee on Water and Land is Senator Keith Agaran, and he will be on remote as well. He'll be on Zoom. We do have Senator Misalucha here. Present will also be Senator Favela, who will be here in a few minutes. We do have Senator Revere, and he is on remote as well on Zoom. Thank you, Chair.
Okay, thank you. With that being said, we'll go ahead to start with the testifiers. And first up, we have Office of Hawaiian Affairs in support.
Okay, here we go. Aloha, Chair Shimabukuro. And members of the committees. My name is Kamakana Ferreira. I'm the lead compliance specialist with OHA. The Office of Hawaiian Affairs stands on our written testimony in support of the measure, but I will offer a brief highlight on why we provided the suggested amendment on relocation funding. We believe the measure rightfully calls for a fiscal examination on how to address the issue and further calls on SHPD to amend rules where needed. So we feel that thus, until such time that rules can be amended and the fiscal examination completed, funding for relocation efforts should not be decided yet, and SHPD should continue to carry out their responsibilities under the state's historic preservation program for inadvertent discoveries and burial inventories. Thank you. And I'll stay on for any questions.
Thank you very much. I think my inclination, if it's okay with you, Chair, is to hear all the testifiers and then we can go to questions. Well, if that's okay with you, unless you prefer to ask now. So then we'll go to DLNR with comments.
Chair, just a second.
Yes.
The chair would like to recognize in person Senator Favela on the Committee on Water and Land, and I believe he is on your Committee on Hawaiian Affairs as well.
Yes, yes. Welcome, Senator Favela. Mahalo for attending. Okay, so then we'll move to the second testifier, which is Department of Land and Natural Resources with comments.
Aloha, Madam Chair. I'm Alan Downer. I'm the Administrator of the State Historic Preservation Division. The department stands on its written testimony to providing comments. I will be happy to answer any questions if there are any.
Thank you so much. Next, we have Kamuela Kalai in support with written testimony only. Is there anyone else here to testify on SB 2067? Okay, hearing none. Are there any questions from any of the committee members?
Question, Chair.
Yes, Chair Inoue.
Okay, for SHPD, thank you, Dr. Downer, for being here. And I noticed that the recommendations and that's coming in from the division and DLNR is pretty much recognizing the different sections in HRS. And I think, Chair, this kind of looks like more technical in nature, some the procedures and making some changes. And I think that's a good step that the agency is doing as well. So can I have OHA? Kamakana?
Sure.
Okay. Okay, according to your testimony, you're saying that OHA shouldn't be paying anything and is bunting to SHPT to address the issue. My issue that I have, which I'm happy that you're here and making comments. I'm just disappointed that you're punting on the payment side to the state as well. And what we're trying to do is to accommodate what the bill calls for. I'm disappointed that OHA can't even take care of their people as they pass. I'm sorry, I'm getting a little emotional. You have $70 million in your financial portfolio. You have 20% of any development monies that's surrounding the state of Hawaii. And you can't even say that we'll give a certain percentage to participate in this program, addressing what this bill is all about. So I'm disappointed. And Chair, so having said that, I'd like to make sure this bill moves along, and through the process, as it goes to WAM, as it goes to the House for continued deliberation, as well as going into conference and see how we can manage this program to make sure that what this bill calls about, addressing the EV and the demise and whatever happens with the weather patterns and coastal erosions on our ocean and just what's coming up in the future, and it's already here with sea level rise. So I'm just kind of disappointed that perhaps if OHA is going to continue and make a decision as to what they'll pay for, but they can pay for any musical endeavors they'd like to participate. They give grants out to some folks who are not even doing any cultural activity, but refuse to participate in addressing our Native Hawaiian burial EVs and the issue before us with sea level rise. And I have to say it, perhaps in the future, near future, as one governor said before, we should look at the Constitution and see what the income for OHA and the 20% should be revised. And perhaps I think that's where a con comes in. It's kind of embarrassing when I have to sit here and read the comments from OHA. It's very embarrassing when we talk about Native Hawaiian traditions, the language, the culture, and can't even say, you know what, let's continue to with this discussion as this bill moves along and see how we can address a financial support for this measure before us and for generations to come. And when I look at it, I says, you know what, maybe we're giving too much money to OHA. Maybe we should look at a constitutional amendment to make sure that half of the income of the 20%, maybe even look at 10% going to Department of Hawaiian Homelands and the 10% going to OHA. But if we're going to continue to fight of who and how they spend the monies that they're putting away and can take care of something as small as SB 2067, shame on you guys. And it's embarrassing that we can't even take care of our own people. So for discussional purposes, Chair, I'd like to make sure that the measure continues and that others can at least share their manao as it moves along. And I think we can't wait. Sea level rise is upon us. So let's take care of the issue. I'm sorry for taking so long, but this is unacceptable to what I hear. Thank you, Chair.
Thank you. Other comments or questions? Sorry, I'm on my phone, so I can't see everyone's hands, so just speak out. Maybe want to,
Chair, I have a
Yes.
question. I
sure.
actually have
Senator
questions
Costa?
for both. I have questions for both Chipti and OHA, but I guess we'll just start with Mr. Downer. So under current statute, is it Chipti's financial responsibility to take care of EV that are exposed?
Thank you for the question, Senator. Yeah, for the most part, the answer is yes. There are some circumstances when burials are exposed as a result of a storm or sea level rise that the responsibility would be with another agency, but the majority of that is covered by SHPD and is part of our operating budget.
So just to follow up on that, if then that were to change and become the responsibility of OHA, it would need to have a separate statute change than is currently being addressed in this measure. Is that correct? Is that your understanding?
I'm not sure about the answer to that. I would have to give it some thought. It's certainly not something that occurred to me when we were drafting our comments. What I pardon me, what I read in the measure was that OHA would be expected to cover whatever cost came from the proactive measures to relocate burials before they get exposed as a result of an extreme weather event or wave erosion. And whether or not that requires statutory change or could be handled in rules, I really don't have an opinion at this time.
So I guess what I'm getting at too is in that case, why would it be different that it's proactive versus any kind of inadvertent exposure that was not based on sea level rise? Placing the responsibility of who was to pay for it, why would, if you could explain why sea level rise exposing EV would be different, would place a different responsibility of where and who finances the interment or care for the EV?
Well, again, as I said, as I read the measure, it calls for an active program to identify burials before they're actually exposed by sea level rise or climate change, and to relocate those that would be potentially affected by those things. Whereas current statute, under current law and rules, when we don't have a role until a burial is exposed or potentially affected by a development. So that I think that's the distinction that I see in the measure and was reflected in the drafting of our comments on the bill.
Okay. Unless somebody has Chair, I have another question. If I can ask one more question to
yeah, proceed.
So currently under law and rules, lands that have burials have protected status when it comes to development. Is this?
Yeah, yes. Burials have to be considered as part of the planning for development, and but whether they are uncovered during development, so they weren't identified beforehand, or whether they're identified beforehand, both when they're previously identified, the decision making on what happens to them rests with the burial councils. If they're identified, they're inadvertent discoveries, that's a SHPD division decision. And in both instances, the law and department policy expressed as a strong preference for protecting the burials in place. So relocation only occurs when there really, appears to be no reasonable alternative to leave them in place and still protect them there.
Okay, but this measure is then addressing a proactive move potentially of known burials. And so in that case, if burials do get relocated based on what we're discussing in this measure, does that then remove potential, protection of that particular land when it comes to future development?
Well, I mean, I think that, as I read it, this is land that is at high, would be at high risk for impact from erosion, or, whether it's a result of an extreme weather event onshore or, sea level rise, what have you. And I would think those kinds of lands would be, not terribly desirable for development in the first place. So, I mean, there would always be, I mean, one of the comments we made in our review of the bill was that, it's impossible to identify 100% of burials ahead of time. The archaeological methods just don't provide any kind of assurance to that. And that's, I mean, not only using best practices today, but anything that we could reasonably foresee. So there's always a potential that, even if burials are relocated, that there are still going to be burials there that have to be dealt with as inadvertent discoveries. But, and in that, if it's, whether it's from, an erosion event or because somebody plans development, those burials are still protected would still be protected by law.
Thank you. And like I said, when it's time, Chair, I have questions for OHA, but I'll yield for now.
Okay. Any other questions for DLNR at this time?
Yes, Senator Favela for Water and Land,
Okay.
both committees.
I guess I came in a little late, but I just have a few questions for this program. How much money will be appropriated to the restoration and the relocation of this EVs and replacing or removing and relocating the EVs? Does anybody have an idea?
Excuse me. Our estimate is, bearing in mind that we don't know where all burials are, and so we don't know how many burials might have to be relocated as a result of this. But right now we spend, SHPD spends between $120,000 and $150,000 a year dealing with inadvertent discoveries. And so, I mean, I think that would probably, that would be the low estimate, would be my guess.
And if you get this, what is the timeline on the rollout?
I'm sorry, I'm not quite sure I understand the question. I mean, that's
if we have the funding, you have the funding now. What would be the timeline and the rollout for the program?
And perhaps I can answer that, Dr. Downer, as well. Senator, according to the measure is the DLNR is to create this program for that includes the burial councils, the Office of Conservation, OHA as well, and other probably other areas that SHPD would probably want to add into this discussional purpose, because I think the measure we're requesting that whatever comes up with their findings will report to us, and this goes into effect 2023 on reporting. But I think having said that, it probably could include moving it to within the next 2 years as well, because of the parts of in section 2, what the division program would include, yeah. And so it's up to the review committee, the program, that would come up and look at what's included in the bill, also maybe, and which we hope, and I'm sure Senator Shimabukuro would agree, that other items would be added by the time we have a report, as well as see where we're at, and maybe OHA will change their mind and become financial participants at that time as well. Also, yeah, and good question, Senator. So, you know, it's not like it's going to happen tomorrow. And another thing to add to, when you look at the locations, a lot of our EV burials, most of them have been situated in Kuleana lands. And so, you know, they own the land, they take care, they bury, you know, to Kani, to Wahine on the lands. And just to give an example, with my own family, I'm not Hawaiian, but I'm married to a Hawaiian, my children are. And Tutukani, Tutuwahine, they had their property in Pepekeo in my district. You know, they're buried there. So my kids, we used to take them, go visit. So that's no problem. So, but the ones that are, and you're gonna find quite a number of Kuleana lands that are on water. You know, you have like it on Big Island, Kilakikua, you know, areas, Captain Cook on the water, and other areas in the state. So if we can have some identification, as Senator and I, Shimabukuro, talked about, you know, perhaps the discussions as we move the bill around, others may have some ideas as well, and should be open for discussional purposes as we move the measure through the year, through the session anyway. So that, you know, the families have taken care of their generations who has passed away. And so let's make sure that with a report that would come out from what the findings are, you know, we'll open up for discussions and see what comes out of it. Thank you. Sorry.
Sarah?
Senator Fabello.
Yeah, no,
It's
I
okay.
just get one more
Sure, proceed.
question, yeah. Since we're getting off the subject, you kind of answered all the other questions that I had on that one. So I got a question. So with the revenue that is being used for public land trust, isn't that part of the coming out of the general funds?
Question is for Shifty. Is that it?
Yeah.
Eleanor? Okay.
The majority, well, what? About 2/3 of Shipley's funds are general funds.
Yeah. Sorry, I cannot hear you.
I'm sorry, let me, okay, so what I said was that roughly 2/3 of SHPD's funds are general funds.
Okay, the reason why I'm asking is because we know that the portion that the 20% that is given to OHA, but we're using the public land credits that comes out of portion of the funding come from the Hawaii, I guess the Hawaiian people anyway, going forward on the 20%. Oh, sorry, on the 20%, before the 20%. So some of that funding that should be going or would be going to OHA is part of the public land credits. Can you give me clarification? Is that part of the general funds?
Yeah, I really don't have that information, sir. I'm afraid that's maybe a question for you know, for the Department of Finance, because I don't know how, you know, I mean, certainly a portion of, you know, a roughly $300,000 of Shipley's budget comes from a transfer from the Special Land Development Fund, and you know, that is, you know, I don't understand the ins and outs of it, but that's where the transfer, as I understand it, the transfer of funds from OHA comes from the money generated by the land division. But exactly, you know, how the proportions work out, I just don't have that information.
Yeah, thank you.
And Senator, just to add, the OHA's 20% does not come from general funds, and it comes from royalties.
Yeah.
They get the percentage coming from geothermal. They have a percentage coming from developments, that need to contribute. And then there's a certain percentage goes into the state DLNR to the state. So it's a shared thing, but all of the 20% that goes into OHA is independent from, we don't, the state does not contribute to their 20%. And then, which is like we've seen in the budget, the $17 million in a financial portfolio that's kept aside. So what we're saying is that, you know, we should at least take care of our own, you know, anything that has to do
I'm not talking
cultural.
about not taking care of you, just to get clarification on when the general funds would come into public land trust, you know, public land credit. Because that portion, I mean, that goes there, does it definitely being given to a proportion of what is given to the people. So, I mean, of course, I want everybody to bear their fair share in taking care of our people, but I just wanted to just clarify on the general funds and the public land credits.
Yeah, and over time, we have been neglected in our own distribution of funds to the agencies, and SHIFTIs is one of them. And, you know, SHIFTI is an important agency, and they've been shortchanged with the least income that we should be providing.
Thank you.
Sarah, I have another question. If I can follow up with DLNR.
Okay. Proceed.
Thank you, Chair. Is SHIFTI currently working with island burial councils to specifically address coastal erosion issues? And if so, how?
Okay. So we are, yeah, the answer is no. I mean, we work with the island burial councils. We provide administrative support to them, and, you know, lend our, you know, our advice to them on a number of the issues that are subject to their jurisdiction. But we're, you know, really we're in the reaction mode when it comes to coastal erosion. We just don't have the resources to do anything proactive at this point, either on our own or with the burial councils.
Then I just have my questions for OHA when it's time.
Okay, any more questions for DLNR? Okay, hearing none, then yeah, we can proceed. Go ahead, Senator Casio, with your questions for OHA.
Okay, thank you for being here, and thank you for your testimony as well. So I noticed I know obviously this is a really important issue, but how much consultation in the formulation of this particular measure was included OHA in the conversation about what responsibilities OHA would or would not take on?
That's an excellent question, Senator. To my knowledge, OHA was not consulted about development of this measure. It's not to say that we are very much in support of it. We're just calling for the fiscal examination to occur first, much in the way that Senator Favela was asking about the funding. If you notice in the measure, the funding is blank. And so if we go through the process as prescribed in the measure, to go through the fiscal analysis and also to examine which rules need to be changed, that would allow us to better understand how we could contribute and where we fit into all of that.
Could you then clarify a little bit more on your comments about the funding and the interdivision program?
Well, our comments are to say, like, we are in support, and we're not necessarily saying that we won't fund the effort, but we very much value the interdivision collaborative nature of the measure that's put forth. So the fact that OHA wasn't consulted on the measure is sort of disingenuous to the effort. So in order to get the best out of this, the agencies should come together to make the proper recommendations on where we could contribute and how OHA can more meaningfully effectuate change in the process and get the situation corrected.
And then if SHIFTI was actively addressing coastal erosion issues, especially around these burial issues, would that lend itself to more collaboration and the strengthening that interagency?
This has been an issue for a while, and I don't know know how many senators are aware, but OHA has also been convening a burial sites working group that's been examining the burial sites program, and the topic of coastal erosion and EV being exposed has been discussed at issue, and we will be providing a report to the Senate as prescribed in the resolutions from last session. So we have been working with SHPD and burial councils and various interested parties from the public on the matter. We're taking it very seriously. And we're just simply asking for more time to develop the necessary reports to make the best recommendations possible.
And just one more too is about burial found on Kuleana lands, or burials found on Kuleana land. It's my understanding that most burials are not on Kuleana lands. Is that your understanding as well?
Well, the discussion at hand right now is about burials in coastal land, and most of those, the burials that are discussed at hand are not actually occurring on Kuleana lands. So I hope that answers the question.
Okay. Yeah, thank you. I yield for now.
Any further questions for OHA?
Yeah, I got a follow-up question.
Senator Favela?
I'm not sure if you guys is responsible, but for and I guess because what you're saying is that we're talking about the burial, so should, I mean, the people saying it's like Hawaiians should be responsible for the erosion caused or by like developers and construction companies, like how they go over there. So are we going to be responsible for those kinds of disruption, chairs? I mean, I'm not sure who can answer this question.
I can add, as an example, let me use Kaka'ako. Any development that occurs privately as well, I would say any development that occurs, if there's EV located and construction, and we've had many throughout the years on all the islands, the developer is responsible. SHPD has its own rules. They'll send the archaeologists over, and they're one of the first that appears when and the developers must notify the state as well, but they're responsible for the relocations. But I'm not sure the actual if it has what the rules are, if it has to be away from the development sites or whatever, but I understand most of those that, like in Kaka'ako, have been relocated and accepted. And I think the final decisions for acceptance comes from SHPD as well. Dr. Downer, is that correct? They follow through the process.
So if burials are identified during the archaeological inventory that's required for the development, then the developer has to develop a plan to protect the burials. That may involve some relocation, and that plan is then subject to the jurisdiction of the burial councils. Now, if on the other hand, a burial is not identified beforehand, but it's identified during the actual development process, so we didn't know it was there first, then SHPD handles that. Again, under both circumstances, the state's policy is do everything possible to leave them in place, and we only relocate when it's not possible to safely leave them where they were originally found. Does that address your question then?
Kind of, yeah. Okay, and this is to oil. So out of the ceded public lands, you guys get 20% of the revenue, and the 80% goes to, I guess, the general fund. Is that the proportion of our ceded land percentage? Is that what we're talking about on the ceded public land? That 20% goes to OHA and 80% goes into the general fund?
Well, that's part of the program. That's how the 20% occurs, from to settle the ceded land issue. But the monies come from private developers and the royalties that goes directly to OHA.
OHA?
So what's your question?
That was the question I just wanted to ask. I wanted to see if somebody could answer exactly what you just said. So do you agree with this? I'm asking a question to OHA.
Oh, I see. I'm sorry, I didn't know that was posed to us. Yes, in theory, we're supposed to get 20% of the public land trust revenues, but we don't always get that portion, that amount. And we're always advocating to try and get our fair share. I'm aware of other measures that are being heard today that don't speak to this issue. Does that answer your question? Or
Yeah, no, thank you, Chair.
Okay,
Yeah,
Thank you.
Thank you, guys. Thank you.
okay. Okay,
Any
my-
further questions from any members? Okay, if seeing none, then Chair Inouye, should we go into a breakout room to discuss our decision making?
Sure. You do
Okay.
have a scheduled agenda as well after this, so yeah.
Yes,
We'll go into closed session then.
yes. Okay, welcome back to the committees on Hawaiian Affairs and Water Land for decision-making on SB 2067 regarding burial sites. And after having conferred with our members, we're going to recommend that we pass this measure with amendments. We want to adopt the amendments recommended by DLNR and any technical amendments that SMA may have. And we also want to summarize OHA's testimony and that of the other testifiers in the committee report. And I just wanted to note that if making the changes DLNR recommended will economize this measure, and yet also still it's in support of the overarching goal of the bill. And so I think that a lot of the concerns that were raised by OHA and DLNR about the costs that could be established, could be projected by the original draft of this bill can hopefully be addressed by these amendments. So going forward, I look forward to hearing the stakeholders' response to the Senate Draft 1 of this measure. So that being said, any comments or questions from the members? Okay, so if not, if Vice Chair Keo'olole can please take the vote for Hawaii.
Members, 2067, the chair's recommendation is to pass this measure with amendments. Chair Shimbukuro.
Aye.
Vice Chair goes aye. Senator Ocasio.
Reservations.
Senator Favela.
Aye.
Chair recommendation. Oh, I'm sorry, Senator Ihara. Senator Ihara.
Reservations.
Chair recommendation adopted.
Thank you.
Okay, the Committee on Water and Land, same recommendations on SB 2067 with amendments. Senator Misalucha for the votes, please.
Okay, this is for Water and Land Committee as regards to SB 2067. Chair votes aye. Vice Chair?
Aye.
Senator Misalucha votes aye. Senator Revere?
Aye.
Senator Favela?
Aye.
Chair, your motion is adopted.
Thank you.
Okay,
you.
thank you. We are adjourned.
Thank you, folks.
Okay, aloha and welcome to the Hawaiian Affairs hearing on SB 2122 relating to increasing the Office of Hawaiian Affairs pro rata share of the Public Land Trust. This is OHA's package bill and establishes OHA's pro rata share of the monies derived from the Public Land Trust, transfers monies to OHA for income and proceeds due from the use of public lands between July 1, 2012 and June 30, 2022 that was misallocated, underreported, or underpaid to Office of Hawaiian Affairs. And so with no further ado, I apologize. Thanks for your patience, everyone. We're gonna, and we have for our committee, myself, Senator Shimabukuro as chair, Vice Chair Keo'olole, members, Senators Ocasio, Ihara, and Favela. And so we're gonna begin with Office of Hawaiian Affairs, who is in support. Is OHA present at this hearing at this
Yes,
time?
yes,
Okay.
I'm present, just waiting for
Okay.
the video to
Okay,
open up.
just briefly.
I see everyone now. All right, thank you. Is the technical, can you hear me, Senator?
Yes.
Okay, thank you very much. Aloha uinala kako, Senator Shimabukuro, Vice Chair, Keo Hokalole, and members of the committee. My name is Naunani Kina Ukamali'i, Director of Policy, Chief Advocate of the Office of Hawaiian Affairs. Also appearing remotely and watching these proceedings are the Board of Trustees of the Office of Hawaiian Affairs. For elected officials from all islands, Kauai Ni'ihau included, Oahu, Molokai, Maui, and Hawai'i Islands, and at large. Their collective representation as elected officials is to constituents statewide, all the people of Hawaii. The board moved through its committees and Board of Trustees meetings with unanimous decision, what is now referred to as Senate Bill 2122. And that measure is introduced, upholding OHA's constitutional obligation to the Native Hawaiian people on the matter of the public land trust. Mahalo to the Board of Trustees of the Office of Hawaiian Affairs for attending today. The Office of Hawaiian Affairs strongly supports Senate Bill 2122 and requests that it pass out of committee. Senate Bill 2122 requires that the state uphold its constitutional and statutory trust responsibilities to Native Hawaiians, to account for all ceded lands in the public land trust, the PLT inventory, account for all income and proceeds derived from the PLT, and transfer the full 20% pro rata share of income and proceeds from the PLT annually to the Office of Hawaiian Affairs for the betterment of the conditions of Native Hawaiians. State agencies that collect receipts for any disposition of public land trust each fiscal quarter shall transfer to the office 20% share of each receipt as required. The measure also establishes a past due amount of income and proceeds owed to OHA from the use of the public land trust lands between a period of July 1, 2012 through June 30th, 2022 that was misallocated, underreported, or underpaid. It's incumbent on the state of Hawaii to set right and fulfill its trust responsibilities to the indigenous peoples of Hawaii, consistent with governmental action at the state and federal levels to address injustices against indigenous people. The state of Hawaii's public land trust and responsibility to Native Hawaiians has its genesis in the historical events that led to the illegal overthrow of the Kingdom of Hawaii. Senate Bill 2122 provides the historical, legal, and political context for the injustices against Native Hawaiians and the constitutional framework for the state of Hawaii's obligation to pay what is due. The state has been paying OHA the interim amount of $15.1 million annually, or about 3.8% for 10 years. The state's failure to set right the PLT funding issue and not pay what is due is not one. State agencies that collect receipts for disposition of the PLT funds to OHA, state agency as well, will likely oppose the measure and seek to maintain the fixed, quote, interim $15.1 million paid to OHA annually, and will likely attempt to redefine well-settled law regarding income and proceeds, or what they may say is a receipt to protect their budget. This measure is not about an agency budget war over which agency will receive what amount from the general fund when increasing one agency's budget in turn decreases another. No, OHA supports budget increases to its fellow agencies by the legislature from the general fund and agency process refinements to improve services to our communities, all the people of Hawaii. For clarity, the sovereign or the state's revenue was expressly excluded from the public land trust calculation. OHA's proprietary share to be calculated on proprietary revenue are proceeds, fees, charges, rents, or other income, or any portion thereof derived from any sale, lease, license, permit, or other similar proprietary disposition, permitted use, or activity that is situated upon and results from the actual use of land comprising of the public land trust, and including any penalties or levies exacted as a result of a violation from terms of any proprietary discussion. We question, why is OHA not receiving its 20% share of the PLT income and proceeds? This is a constitutional obligation. So we attached to the testimony, December 2021 report of the Department of Land and Natural Resources, their accounting, which provides an accounting of all receipts from lands described in Section 5F of the Admissions Act for fiscal year 2021, as it is entitled, details receipts by the department, and it also shows its failure to pay the full 20% as required. See, also attached to this testimony is OHA's PLT revenue receipts for fiscal year 2010 to 2022. And this shows what OHA receives. It also shows the carryover of excess funds, or what is referred to as the CAPTA trust account. Now, state revenue, there seems to be some confusion when we talk about what is the public land trust. So let me attempt to clarify it. State revenue, which is expressly excluded from OHA's pro rata share. This includes taxes, regulatory or licensing fees, fines and penalties or levies, registration fees, monies received from any public educational institutions, including the University of Hawaii and the community college system, from educational programs and ancillary services such as tuition, registration fees, meals, books, grants, or scholarships, interagency and intra-agency administrative fees or assessments, monies derived from or in support of penal institutions and programs, grants, carryovers, pass-throughs, federal monies, including federal aid grants, subsidies, and contracts. The state's obligation is firmly established in the state constitution. And the Supreme Court concluded in State versus OHA, which invalidated Act 304, but concluded that it is incumbent on the legislature to enact legislation that gives effect to the rights of Native Hawaiians to benefit from the ceded land trust. Okay, let me take a moment here. This bill is about the ceded land trust. It is not about budget issues that result from the general fund or other funds. This is about the ceded land trust. OHA has other funding resources, and it utilizes them for Native Hawaiians. This is a very specific revenue source that we're talking about here today. And that's why there's the time taken to make that distinction between what is included, i.e. the sovereign or the state's revenue that was expressly included, and what agencies are collecting for disposition of the PLT funds to OHA. And there's somewhere therein, this is what we're talking about today. So I want to make it clear that what the Office of Hawaiian Affairs is doing today by this bill 2122 is upholding OHA's constitutional obligation to the Native Hawaiian people on the matter of public land trust. Practically, how is that happening? Let's look at the OHA and its organization. In 2020, OHA embarked on its 15-year strategic plan for years 2020 through 2025. Mana'i Mauli'ola includes 3 foundations, Ohana, Mo'omeheu, and Aina. Now, OHA's strategic plan alignment and reorganization resulted in reductions in overhead and increases in funds to the Native Hawaiian community. In 2018, a base of about 6 million deployed to the community has increased to over 16 million in 2021. It's OHA's intent to continue this trend and practice. The annual POT funding request of 78.9 million will likely be deployed through multiple vehicles, including OHA's grants program and MOUs and collaborations with entities, Native Hawaiian organizations, Native Hawaiian communities, to create programs regarding housing, prisons, education, and welfare, those needs and concerns, all the disparities that are documented, all the disparate conditions of our community. Those funds will be used to address those needs and concerns. Native Hawaiians and the community at large will be an integral part of this process. In upholding its obligation and making the request for POT income and proceeds that are due annually and past due, the Office of Hawaiian Affairs Board of Trustees is upholding its constitutional obligation, and it does so on behalf of the Native Hawaiian people. These efforts to resolve the POT dispute with the state and state agencies does not settle claims of the Native Hawaiian people to income and proceeds of the pro rata portion of the public land trust. The board will not co-sign to a breach of its fiduciary duties and constitutional obligation to Native Hawaiian people. It urges the state to uphold its obligation as well. The claims of the Native Hawaiian people to income and proceeds of the pro rata portion of the public land trust, it's their money. OHA encourages the Native Hawaiian community to come forth and testify on this important measure. Let the legislature know that without this constitutionally mandated funding, how they have suffered. Let them know about the challenges that they incur in education, in health, jobs. Let them know. Thank you very much to the committee. I'm grateful and mahalo for your support. And we at the Office of Hawaiian Affairs are urging that you pass this important measure out of the committee. Thank you very much.
Ms. Kamali'i, thank you so much. I just want to remind everyone that we have to adjourn by about 2:30, I believe. So if we want to pass this measure, we need to vote by 2:30. So it's about half an hour we have. So next is DLNR in opposition.
Good afternoon, Chair, members of the committee. I'll just, Ian Hirokawa with DLNR Land Division. I'll just stand on our testimony in opposition and be available for any questions. Thank you.
Thank you. DOA with comments, Department of Agriculture. Oh, sorry, are they here? Okay, if not, Attorney General's office with comments.
Good afternoon, Chair, Vice Chair, members of the committee. Craig Ehud, Deputy Attorney General, offering comments. Just wanted to summarize 3 of our primary points in our written testimony. It is the legislature's sole authority to determine the Office of Hawaiian Affairs pro rata portion of the income and proceeds from the public land trust. And in 2006, the legislature set an interim amount of $15.1 million per year. Now that is an interim amount, but nonetheless, under current law, the state has not underpaid or misallocated funds on its legal obligation to transfer funds to OHA. The other points I'd like to raise are that it is the legislature's sole authority to determine the pro rata share. However, there are other beneficiaries and 4 other purposes of the public land trust that should also be considered when OHA's pro rata portion is being determined. And beyond that, I'm available to answer any questions. Thank you.
Thank you, Mr. Iha. Next we have, let's see, where are we? Department of Budget and Finance with comments.
Good afternoon, Chair, committee members. I'm Craig Hawai'i, Director of Finance, and with me is Neil Miyahira, the Budget Administrator. You have our written testimony offering comments. Just a couple of more budgetary technical points. As you know, airport revenue is subject to federal law. Also, certain, maybe unanticipated budget effects may result from this, from things such as HHSC, where they basically operate on a subsidy, and if they have to pay more, we have to subsidize more from the general fund. And also more of a technical thing here, which is going to be applied to fiscal year 22-23, the 638 million general fund appropriation. We're currently subject to a maintenance of effort requirement from the U.S. Department of Education that requires us to maintain proportional expenditures for DOE and UH. So the additional amount that would have to be appropriated to DOE would be around 180 million, and to UH would be about 60 million to maintain the proportionality on a $638 million general fund appropriation. Thank you.
Oh, thank you, Mr. Hawai'i. I appreciate it, Director. Next, we have Hawaii Health Systems Corporation with comments. These are all just written testimony. Center for Hawaiian Sovereignty Studies opposition. Native Hawaiian and Pacific Islander Hawaii COVID response and support. Rich Robin Vanderpool opposition. Kupuna for Mo'opuna support. Kanani Iaya support. Lehua Itokazu support. Is anyone else that I missed for this bill, SB 2122? Okay, seeing none, members, any questions, comments? Okay. Sorry, I'm on my phone again, so, okay. Oh, no questions or comments, wow. All right. Okay, in that case, members, should we go into, I guess we'll go into a breakout room for decision-making discussions. So, okay, so if we can recess for decision-making. Okay, so we are back from recess, and after having conferred with my members of Hawaiian Affairs Committee, the chair is going to recommend that we pass this measure with amendments. As recommended by the Money Committee, we're going to zero out the specific dollar amounts that are being requested in this measure. However, we will list the specific dollar amounts in the committee report, so it'll be made clear to anyone comparing the SD1 with the committee report what amounts OHA has come up with. And then we're also going to have any technical amendments that SMA may recommend as well. And so are there any, and well, of course, and then summarize, the testimony received, the concerns raised in the committee report as well. Is there any discussion or questions from the committee? Okay, then seeing none, if Vice Chair Keoho Kalole, if you could please take the vote.
Okay, members voting on SB 2122, the chair's recommendation is to pass this measure with amendments. Chair Shimabukuro.
Aye.
Vice Chair goes aye. Senator Ocasio.
Aye.
Senator Ihara.
Aye.
Senator Favela.
Aye.
Chair, your recommendation is adopted.
Okay, thank you very much, everyone, for participating, and we will be adjourned. We'll see you on Tuesday.